This is far too sophisticated for me. Charles? I suppose while Charles is doing this, it seems an appropriate time to thank Mary and the organisers of what I think is a really tremendous, it's a fantastic occasion. It's been fantastic so far. Hopefully it won't take a downturn now. But also it's a fantastic thing to have this kind of conversation. And thank you very much both to Mary and to the other organisers for facilitating this, but also for the Centre and all the work which it is doing in facilitating these kinds of conversations to happen. Now, following Amita's presentation, we're coming very much down to earth, I'm afraid. Because what I want to talk about is the Irish reform process, which at the moment is at a very delicate stage. We're coming towards the end of what's been quite a long process. The questions which Amita raised, the questions which Bernadette raised, the questions which Phil, I'll be coming back to Phil's arguments as well. These questions are incredibly important, and it's very, very important for us to remember that this phase of law reform is not the end, God help us. We're going to have to keep going and go back in again. We've got to keep an eye on what's happening. But what I'm talking about is I'm starting from where we are. I'm starting from where we are now. At this moment, and I'm going to be dealing very much with this. There are a lot of questions of principle that I'm not going to be addressing. I'm going to be trying to deal with what we've got and where we are now. Now, I put this up, I deliberately put it up and squished it because I wanted you to get a flavour of how long this process has been going on. Nearly 20 years. It's quite extraordinary. In the meantime, we've had a lot of things happening. We've had the convention go from start to finish while we've been messing around. Quite extraordinary to think. We managed to get, and you'll see there, 153 states, including us, have signed the convention. 114 have ratified it. From start to finish to ratification, and we've been where we've been. So that of itself is interesting. One of the things I'm going to talk about first here is why this inertia. Why has it taken so long to get anywhere? And I'm going to talk a little bit about that. My main concern, though, is to talk about gaps. And the gaps created by the fact that we have two model systems. We've got two systems working alongside each other. And the problems which they create for the realities of our current law reform process. And I'm doing this very deliberately because I think we really need to know about these problems. We need to be aware of them so that when legislation comes out, and we're looking at getting legislation soon on mental capacity. We've got the interim report of the steering group, and it's wonderful to see them here. We've got that has just come out, so we're going to see amendments to our mental health legislation. But civil society has to be alert, and that, in a sense, is one of the kind of key arguments which I'm going to be making today, which is we need to be alert, we need to be ready and able to respond. Now, the world has been happening, the CRPD has been happening, the jurisprudence of the European Court of Human Rights has been happening. The 2001 Act, if you read the debates, they are extraordinarily self-congratulatory. The parliamentarians were so delighted with themselves because they were doing a human rights-based model. They said it a lot. It's actually worth reading in terms of reading congratulations or self-congratulation. By the time the Act came into force, of course, the jurisprudence of the European Court of Human Rights had moved on. So it was out of date before it even started, which was obviously problematic. Not to mind, of course, the convention. So why have things been so slow? Now, there's the obvious. Political will hasn't been there. There aren't votes in mental health. You're never going to get elected on the basis of your mental health provisions, or at least there aren't very many votes in mental health. Obviously, we've had other distractions, but just remember, things only really started going downhill economically in 2008. So it's not as if that it's been you know, while we had money, while we had resources, we weren't dealing with mental health and we weren't dealing with mental capacity. Now, to be fair, something which is worth noting, we also haven't had something they've had in other jurisdictions, which is a high-profile law and order case. We need to lock them up because they're going to kill people. Because that's what you see. If you look at a lot of jurisdictions, if you look at a lot of the US jurisdictions, if you look at the UK, you had a high-profile killing, which it was argued, usually media-fueled, was caused by a flaw in mental health legislation, and therefore let's legislate to solve it. Now, in fairness, we haven't had that kind of thing here, and that I think is something to be grateful for. It has allowed the kind of sputtery debate to take place in at least a context which hasn't been driven by that particular media-fueled attitude. The other thing, I suppose, though, when we think about why the slowness, why the inertia, we have to look at the courts. Because the courts have facilitated and encouraged the inertia. Judicial attitudes have been quite extraordinary, and it is actually worth taking a minute or two to think about them. Our variant on HL, EH versus St. Vincent's Hospital. We saw a woman who was deprived of her liberty by any standards, and we saw the Supreme Court saying that this was in accordance with the, and I put it up there, the overall scheme and paternalistic intent of the Mental Health Act. Now, there are flaws in the Mental Health Act, lots of, but that actually is an under-reading of a more sophisticated piece of legislation. It wasn't that bad. They didn't have to do this. We saw this year, earlier this year, PL, versus St. Vincent's Hospital again, and I know Anya is going to be speaking to you in the afternoon. And we saw yet again a man deprived of his liberty, not allowed to leave, admitted as a voluntary patient, not allowed to leave, and the court said, that's okay. That's fine. We're not going there. We're not. There is, Phil has talked about it, there's ECHR case law. What did the courts do with the ECH law or case law? They said it isn't relevant here. So they ignored the actual rights, which are well established, and talked about the paternalistic intent of the legislation. Now, they've been slightly better on mental capacity, but given we're working with the Lunacy Regulation Ireland Act of 1871, that's not a surprise. They said it wasn't a great piece of legislation. I'm paraphrasing. But, and this is really interesting, no decisive kick. In Re Francis Dolan, they had the opportunity to say, this is probably unconstitutional. The constitutional challenge itself had kind of died off at that stage, but they had an opportunity to give the legislature a bit of a kick, and they didn't take it. So our courts have not, putting it mildly, played a stormer on this one. Why am I saying this? Not to have a sideswipe at the courts, although that's obviously fun as well, but because it's going to be the same courts who are going to be interpreting the law. They're not going to change. We're going to be working with the same courts. We're going to be working with the same service providers. We're going to be working with the same managers. And this is so important to remember. You have your law reform. It's wonderful, but your law reform will only bring you so far. So an awareness of the circumstances and the people we're working with, as in the people who are enforcing and implementing your law, from judges right across the board, that has to be part of our thinking and that kind of awareness and that kind of education and that kind of thought. Now, by the way, it is worth saying that the inertia has been countered by centres like this, by the Amnesty campaign, by mental health reform. There have been attempts to counter the inertia, but what you might describe as the establishment hasn't really gone there. It's been coming from civil society. That's why civil society has to stay engaged. Okay, this is the same list, but I divided them, because this is in fact what our reform process actually looks like. we've got our mental health reform, we've got our mental capacity reform, and pretty close, never the twain shall meet. And that's what I want to talk about for the rest of my presentation. The particular challenges with trying to do reform when you've got two sets of legislation, when you've got two sets of processes. Now, there's a lot of arguments to say there shouldn't be two sets of processes, but that's not where I'm going today. I'm saying, what challenges has that posed to date, and how can we address them now? I guess I'm going to talk a little bit about that. So, briefly, to give you a picture of the dual model. You've got your Mental Health Act, and then you've got everyone else. Mental Health Act applies to patients who are compulsorily admitted, who have been formally admitted, in or about 2,000 people per annum. They get a tribunal review of detention. They get a second opinion on treatment. Now, quite frankly, the second opinion system is not a particularly good one. It's not an independent second opinion. Nonetheless, there are procedural protections for people in this situation. Everyone else is voluntary. And this is what the court said in EH. They said everyone is voluntary if they're not involuntary. The departure from the English language, obviously, point aside, that's essentially what they said, and that's been approved by our Supreme Court. That's about 17,000 people every year. Of those, and I think it was Mary cited some figures at the Oroptus Joint Committee, about 6,000 people lack the capacity to consent or refuse to be admitted. So these people are voluntary patients lacking capacity. We also in Ireland, because Vision for Change, remember, is only from 2006, we still have a lot of long-stay patients. Elderly people particularly, over 65s. We have a lot of over 65s. These people have been in this situation for pretty much ever. Calling them voluntary is clearly daft. They get no reviews of detention. They get no reviews of treatment. So you have this cohort of people who are called voluntary, who get none of the protections that go with being formally admitted, and it's that cohort of people that I'm concerned about in this particular talk, and it's that cohort of people that I think we need to worry about as we engage with the law reform process. This is the dual model system. I spent a while trying to decide which pictures to go for, but anyhow, this is important in the sense, this is the realities. This is the challenge of reform in the dual model system. Okay, so we've got mental capacity legislation is coming out of the Department of Justice. Mental health reform is coming out of the Department of Health. Now we've got Kathleen Lynch, who is the Minister for a lot of things. I have the full title. She, in a sense, is there to bridge the divide. But of course, legislative reform is all about detail. It's about what you do on a wet evening in January, writing the detail of the legislation. And that, of course, is done at a departmental level. It doesn't really matter what these people do. It's down here that matters. The challenge is, two challenges. First one is, and I apologise for using the cliche, but sometimes cliches actually are important. You don't have the joined-up thinking. And I don't just mean joined-up thinking at some abstract or abstruse policy level. I mean on the dirty detail, down there on the detail. Now, I put this picture in because you get something called legislative ping-pong. It's an idea I used to, or interdepartmental ping-pong. I picked this picture because of the enthusiasm which the player was showing. Bouncing the hard issues from department to department. Oh no, that's justice. Oh no, that's health. Now, the problem, and I do apologise for this, but somebody will eventually drop the ball. Sorry, terrible joke. But the point is that with interdepartmental ping pong, this becomes somebody else's problem, and nobody gets to sit down and actually say, right, what's the issue here? How are we dealing with it? Now, the other challenge, and it is worth bearing this in mind, there are different policy drivers for mental health law and mental capacity law. So you've got different sort of engines. I just want to talk about them a little bit. Mental health, you have this public protection angle in mental health law. In mental health legislation, there's a public protection angle. It overtly limits people's rights. But because it overtly limits people's rights, it gives them certain protections. So it doesn't look as pretty as a piece of work. Now, I think with the interim, the steering group's recommendations, hopefully it'll look a little bit prettier. But it doesn't look as pretty, but you do actually have the potential for hard, enforceable protections. Mental capacity looks much prettier. By which I mean you will see express reference to rights protection. You will see a lot of references to supported decision making. It'll be good on the language. But where mental capacity legislation nearly always falls down, it's weak on the delivery. So you will have a situation where they'll talk a great deal about supported decision making and its fundamental right, etc., etc. But when you get down to the dirty detail of what is actually being given here, how is supported decision making going to work? What are you going to give? What rights, what enforceable rights are you going to give? That's where mental capacity legislation generally falls down. Now, very, very briefly, we're coming, as I say, to the end stage of the game. And I want very, very briefly to talk about the human rights parameters. And I'm going to do so briefly because others have done so in a great deal more depth. In terms of the parameters we've got to work with, we have to work with the case Phil referred to earlier, HL versus the United Kingdom. This requires that if a person is being deprived of their liberty, they are entitled to procedural safeguards. That's a requirement under the European Convention of Human Rights. There is a positive obligation on the state. Now, I like positive obligations. I believe in positive obligations, the more the merrier. There is a positive obligation on the state, recognised in Stork versus Germany. There is potential for developing that. Positive obligation to ensure that the steps are in place. So that can't be avoided. That's a requirement. The other requirement, and I think this has potential, well, maybe, is the recent decision out of the European Court of Human Rights, Stanov versus Bulgaria, where they said if you're going to deprive some of their liberty, you've got to consider alternatives. What alternatives are available? Now, when I read this, I thought, excellent. Maybe we might finally have some notion of community, appropriate supports in the community, that kind of thing. Now, to be fair, not long afterwards, in a later decision, I think the European Court of Human Rights kind of dropped the ball. They certainly held that a very perfunctory consideration of alternatives was sufficient. But the idea is still there, that notion of alternatives, and that's something which I think, hopefully has the potential to develop. In terms of the CRPD, I've identified, and Phil has talked about, has talked about Article 14. Article 19 is important. Equal right to live in the community. And then obviously Amita has talked in great depth about Article 12 and all that involves, including a right to supported decision making. Not just it's a nice idea, a right to supported decision making. Okay, briefly let's talk about the reform options for my group of people. These 6,000 people, that's an awful lot of people who are deprived or who are admitted with no protections. That's an awful lot of people. Okay, so what can we do? We can apply the Mental Health Act. We can apply the deprivation of liberty type safeguards. Now, after listening to Phil, I'm sure none of you are going to want to do that one. And then there's this notion of a normative shift, and this is the thing I'm going to be trying to sort of talk about. Normative shift to patient-centred assessment of reform. In other words, what do people who are likely to be affected want? What do they need? Now, you might say, isn't that an obvious point to make? But I'm going to talk a small bit about the deprivation of liberty safeguards, because I think that kind of question really isn't asked. Instead, we see technocratic approach, essentially, to human rights. Human rights as something that need technically to be complied with. And I think Phil brought that point out, but I just want to say one or two other things on that. Okay, applying the Mental Health Act. Let's face it, the Mental Health Act is neat. NEAT is not bad. You know, there are advantages in NEAT. It's probably ECHR compliant, although I would question whether the by ECHR compliant, I mean compliant with HL, although I would question there is no requirement to consider alternatives in section 3.1a. So reformers, that's something which might be worth, you know, in light of standard. There are disadvantages. Very limited suitability for people who aren't objecting. The Mental Health Act provides tribunal hearings, but if you're not objecting to being there, in other words, if you're compliant, if you're saying, look, I'm here, you know, whatever, you know, I don't really care, I'm here, the Mental Health Act doesn't actually give you anything. Question of value of tribunal hearings, there is cost, but there's also value. If a person lacks the capacity to instruct a lawyer. Now, I fully appreciate that we've got two different functions there. Nonetheless, what good is a tribunal hearing if you've got somebody who does lack capacity to instruct? The other point is treatment protections come so late. 3 months is an awful long time to be on, let's say, sedative medication without anybody having any overview of what's happening. And that's, remember, our people here are lacking capacity. So we're looking at 3 months before we go in and say, well, hang on a minute, is this a good idea? It's an awful long time. Deprivation of liberty safeguards. I put this up deliberately, not because I wanted you to read it, but because I wanted to get the complexity across. But Phil has done that beautifully. It is worth, though, thinking about a couple of things about the deprivation of liberty safeguards, which I think Phil didn't raise. And they're confusing, they're complex, they're lack of understanding. You've got new gaps. What is a deprivation of liberty? But there's a couple of things that I think are also worth drawing out. They do very little. They are totally about a technical solution to a human rights problem. They're not about, here's someone, what do they need? They're about, how can we, the state, in this case the United Kingdom, how can we cover our ass, putting it simply. Couple of points. No protections on treatment. So the deprivation of liberty safeguards do not protect in respect of treatment decisions. The other thing is there are representatives, but there's a very clear power imbalance. This is a man called Stephen Neary, and this is his father. Stephen was admitted to a care home as part of a respite care. You know, his dad needed a break. The parents had recently separated. The dad needed a break. Stephen went in voluntarily to the care home. Mr. Neary was Stephen's representative. It took Mr. Neary, who was happy to care for Stephen at home, and Stephen wanted to be cared for at home, took him nearly a year to get Stephen home. And the decision is really worth reading. So the first point is really worth reading, but the judge said, you know, he admired so much. The essential attitude was, wear down Mr. Neary. Let's keep him at it. Let's drag it out until he gets worn down. The judge said, I admire so much his determination to continue. But that's under the deprivation of liberty safeguards. Okay. I am conscious, because the last part of my presentation is about asking what people want. And I'm conscious that there's an irony in me then standing up and saying this is what people want. So this was Snoopy's, obviously religion is everywhere, this is Snoopy's take on epistemological humility in the religious context. So I appreciate the irony of me saying this is what people want, and I also do this from a perspective of humility. So I'm very conscious of that. Some suggestions though. Watch out for avoiding technicalities. Enhance the supporter's role. This is, everybody needs someone in their corner. Katie Taylor, never miss a chance to have a picture of Katie Taylor, who's going to win us Olympic gold, hopefully. I think we need specific oversight. I think we need something on long-term medication, and I think we need something on ECT for voluntary patients, or for patients who have not been formally admitted. And we really need to work on this support framework. They're my suggestions, and as I say, they are made in a spirit of humility because I appreciate the fact. My point, though, is we do need a normative shift. We need to say not what will technically comply with the ECHR, but what do people want and need. If we can do that in our heads, we can get a better, I think, end game. Now, the interim report of on the Mental Health Act came out At least I found it yesterday morning. So I frantically added these slides. They're not in your pack. There are a lot of terrific things, and obviously we're going to have some members of the steering group speaking to us later. A lot of very, very good things. I've listed lots of things there which I think are really positive. However, I think the gap that I talked about is continuing. This is not the fault of the steering group. This is the fault of the system. But it's a fault, and I'm going to explain how the falling between the two stools is continuing. But it's something we need to be totally alert to at this point in the reform process. So these are all the really, I think, excellent suggestions or recommendations. Okay, so remember we talked about this interdepartmental ping pong. So how did the report deal with the dual model system? Now, it says that there is an anticipation that many of the shortcomings of the Mental Health Act will be addressed in the capacity bill. Whoopee, but will they? The steering group met with the Department of Justice. So the steering group is coming out of health, met with the Department of Justice, 2 meetings. That's terrific. But gosh, we're going to need an awful lot more meetings if we're going to develop. There is a recognition, and this is good, a shared recognition of the need to dovetail the 2 pieces of legislation. But shared recognition is all very well. It's when you get down and dirty with the detail that it's going to become incredibly important. So yes, there is an attempt to deal with the dual model, but that attempt is really going to have to step up a pace as things progress. Now, very briefly to take you through the recommendations. In respect of voluntary, it is recommended by the steering group, means a person who consents on his or her own behalf or with the support of others, or a person on whose behalf a personal guardian appointed under the proposed capacity legislation consents to such admission. Okay, so the personal guardian has got a lot of power in this model. That's all very well, but until we see what the personal guardian, their right, their duties, their obligations, their powers, until we see the Mental Capacity Act, we can't know what this recommendation actually means. So that's my first point. So watch out for this one. Watch out for the Mental Capacity Act. Are they taking cognizance of the needs in their framework for personal guardians? Remember, their framework is probably going to be applying to everybody, not just to people being admitted to hospitals and care homes. It's going to be a much more general framework. Are they recognising the particular situation of people lacking capacity being admitted? We'll have to wait and see. We really have to keep our eyes open and watch this one. Now, in terms of protections for voluntary patients, the recommendation is no need for external oversight where there's capacity. Patients with a personal guardian, protections provided under capacity legislation will provide sufficient protection of the rights of the individual. Terrific, if they do. So again, we've got to really watch this one. Patients with fluctuating capacity, recognition of external oversight. 2 things very positive. Inspectorate power of referral of situations of patients lacking, or voluntary patients to the tribunal, that's a very good thing. Information provision, real legal rights, that's a very good thing. These are terrific. But my concern is the personal guardian. It's being ping-ponged at the moment. This is not the fault of the steering committee, this is the fault of the system. But it's being ping-ponged back to justice, back to the personal guardian. So we've got to watch this space. We've got to see what the personal guardian is going to involve. In respect of changing legal status, and this really is a problem within an institution where somebody has been admitted voluntarily, says they want to leave and suddenly finds their status changed. Again, a recognition that that should not be undertaken lightly. Acceptance of the need for treatment should be implicit in voluntary admission, and patients should be allowed to leave, subject to a 12-hour holding period, which is shorter than the UK model. On consent and incapacity, again, possibility that patients were unable to give consent, but that has to be, the group said, has to be acknowledged in light, examined in light of the capacity legislation. And this is a quote. The group is hopeful that the protections provided to patients under that legislation will be sufficient and no further protections will be required under mental health legislation. Great if it works. I don't think it's going to. We have to wait and see. But the point I'm making again is, unless the capacity legislation is pretty sophisticated and pretty aware of the real needs of real people, this ball is going to get dropped. Endgame. Briefly, watch out for empty rhetoric. You will hear an awful lot of talk about human rights from the politicians. Look behind the rhetoric. I think civil society has to look behind the rhetoric. And the prettier the rhetoric, the more you have to look behind it. Details matter. What is actually being delivered? And this is fundamental. The importance of holding our elected representatives to account. Now, Amnesty, mental health reform, mental health lawyers, there are a lot of people from civil society, but every one of us has to hold our elected representatives to account on this one. Now, law reform is not the end. It's not even the beginning of the end. Monitoring matters, changing attitudes matters. These things down in the reality, down in the trenches, these are the things that matter. But we have a chance now to influence the legislation. I don't think we're necessarily going to get the best piece of legislation or the best legislative framework that we can imagine. Of course we're not. Amita's talked about all sorts of wonderful, promising things. So has Bernadette talked about wonderful, promising things. But let's try and get it to be at least not too bad. Now, you might say that's a pretty small objective, but actually it is one which is worth fighting for now. And we are in the end game. We are coming to the point where we're going to see the legislative end game for now. It is important to be informed and to make our elected representatives do this properly. Thanks.